everybody, and we are very honored to be holding oral arguments today at Walnut Hills High School. I am excited that the students are here watching our oral arguments and hopefully can appreciate that third branch of government that not enough people pay attention to. And we will be answering questions afterwards, so if you have questions, save them for afterwards, and we are happy to answer your questions. I am Judge Ginger Bach, this is Judge Candace Krause, and this is Judge Robert Winkler. And I guess we will go ahead and get started now. We have 3 cases on the docket. Our first case is State v. Jones. Ms. Nelson?
Sarah Nelson on behalf of Ms. Jones, ready to proceed.
Joshua Loy on behalf of the state, ready to proceed.
Okay. You may get started anytime that you're ready. Would you like to reserve time?
4 minutes, Your Honor.
4 minutes?
Yes, please. Good morning, Your Honors, and may it please the Court. Good morning, opposing counsel. Sarah Nelson on behalf of the appellant, Ms. Yvette Jones. This case concerns an assault allegation and an alibi defense. The trial court found Ms. Jones guilty in this case because it did not find her alibi that she was at work to be credible. Ms. Jones, her fiance, and her mother all testified in this case that Ms. Jones was not at the scene, she was at work. But the trial court specifically said, after reviewing their testimony, quote, it did not find the alibi defense to be credible. It said there were no independent witnesses to verify that the defendant was at work, and there were no records indicating the defendant was at work presented to the court. The trial court's findings in this case show that additional alibi evidence would have, the additional alibi evidence that was submitted in the motion for new trial would have impacted the outcome in this case. So this morning, I intend to focus on that evidence and then the first and second assignments of error. The first assignment of error concerns the motion for new trial, and it's our position that the trial court erred in denying that motion. There are 6 factors to consider on a motion for new trial claim, but this case really boils down to 2. 1, whether there was a strong probability that the newly discovered evidence would change the outcome of the case, and 2, whether the evidence could have been discovered through the exercise of due diligence by counsel. Now, as previously stated, the trial court took issue with the fact that...
Ms. Nelson, just real quick, what is our standard of review before you get started?
Yes, this is an abuse of discretion standard, whether or not the trial court abused its discretion in denying the motion for new trial, which means that we have to show that the trial court's decision was arbitrary and unreasonable. In this case, we know that on the first prong that the evidence created a strong probability. For context, the evidence in this case is an affidavit from the PNC bank manager that says my client was at work at 9 a.m. And a surveillance video that also demonstrates that she showed up to work on the day in question at that time.
Ms. Nelson, when did the victim allege that the assault took place?
The victim testified that the events in this case took place between 7:30 a.m. and 8:30 a.m.
So if it happened at 7:30, would that have given the defendant enough time to get to work?
If the actual assault happened exactly at 7:30, then yes, that is a question still at play, whether or not the defendant could have been on scene. But there are several things that happened in that hour time frame. This case started with words, altercation between neighbors. The actual assault occurred sometime within that hour. The police showed up within that hour, according to the victim, and the police verified my client's vehicle at the scene within that hour, according to the victim. Now, if my client has to take 45 minutes to get to work, that means she left between 8 and 8:15 to get to work at 9 o'clock. That means all of those events happened in a 45-minute window, and I think that becomes less probable when we know that she actually arrived at work at 9 o'clock. So why this evidence is important is because it changes the credibility landscape in this case. And we know that the trial court rested its decision on the credibility of the testimony. So it calls that time frame into question. It's possible that the court still could have believed that, but we know that there's a strong probability that the outcome would have been different because its finding of guilt was based on the absence of the PNC evidence.
And can you help me with the record? The police, you said that the victim in this case said that your client was there when the police showed up?
Yes, the victim's testimony was that my client retreated back to her home and then did not come out when the police showed up.
Did the police testify to that?
They did not.
Okay.
So it's a credibility question whether or not that hour time frame included all of the events that she testified to. That hour time frame becomes much shorter when we know that my client was at work at 9 a.m. She could not have been there for a 45-minute period because of the drive it took from her to get from her house to work. So that goes to the strong probability that the outcome would have been different. The other prong on the motion for new trial that's at play today is whether or not my client or my defense counsel could have discovered this evidence through the exercise of due diligence. Trial counsel maintained that it attempted to subpoena the proper parties for PNC and ran into red tape, corporate, legal issues that couldn't make that connection prior to trial.
Let me ask you, man, wasn't there an indication that the person in possession of the video and audio didn't receive the subpoena until after the trial? Am I correct in that?
That is correct. The person who submitted the affidavit did not receive their subpoena until after trial. Now, that specific subpoena, just out of duty of candor to the court, seemingly was not filed until after the trial. There seems to be some other attempt by defense counsel to make contact with PNC prior to trial, and that was one thing that was a hang-up by the trial court, is that there's no record of that in this case. I don't know necessarily if every single subpoena that's sent in the case gets documented in the trial court record, but defense counsel maintained if there was an attempt made to contact PNC, it was not fruitful, and they went to trial.
Counsel assumed there was going to be surveillance video at a bank, right? Like, every bank has surveillance video. Isn't that right?
Yeah, yes, you're right.
They issued this subpoena assuming that there would be some sort of video that would capture your client on it, right?
Yes.
So if he didn't get the video in time for the trial, why not just ask for a continuance?
That is a fair question, and one that the trial court raised in this case and criticized defense counsel for not doing. You know, if there was a problem with outstanding evidence, why did you bring it to the trial court's attention?
Right. Well, that seems like a reasonable question to ask when we're looking at due diligence, right?
So my position is that the attempt and the representation an attempt was made is enough to satisfy due diligence. But if the trial court's representations, you didn't seek an investigator, you didn't ask for a continuance, etc., if that is reasonable to deny a motion because of lack of due diligence, then I would argue that's the bar, and defense counsel fell below it, and to the extent that they were ineffective, which brings me to my second assignment of error. The trial counsel in this case fell below the bar that the trial court set in this case. Didn't ask the investigator to go out and get that surveillance, didn't send subpoenas because they're not of record until after the trial occurred, and didn't ask for any continuances if there was outstanding discovery, such as the surveillance video. And the standard for ineffective assistance of counsel is, did counsel's performance fall below an objective standard of reasonable representation? And the trial court laid out, in my opinion, what is reasonable representation in this case, and trial court absolutely fell below that standard. If we're going to find that he didn't exercise due diligence, it was below objective reasonable representation. The second question on an ineffective assistance of counsel claim is whether or not that failure to perform reasonably constitute prejudice to my client's case. Prejudice is the same argument as with respect to the strong probability that the outcome would be different. My argument is the same. The trial court in this case noted on the record that it was troubled by the lack of PNC evidence in this case, and that is what trial counsel failed to produce for the alibi defense. Had counsel produced it, trial court may have been more persuaded by the alibi defense. We know that because of his findings. There's also case law to support that the failure to subpoena certain witnesses could amount to ineffective assistance of counsel. In order for that failure to meet that claim, the testimony at issue must be significant to assist the case. And we know that the missing subpoena, the missing evidence as a result of the failure to send that subpoena would have assisted the defendant's alibi defense in this case.
To me, the key in this case is whether this video would have mattered.
Yes.
Ultimately, right?
Yes.
So we have a video of her walking into the bank. Is it at 9 a.m.?
Yes.
Okay. And then the victim said that the assault occurred between 7:30 and 8:30.
Correct.
And she testified that she takes a half hour to get to work.
45 minutes.
45 minutes.
Yes.
So she would have had to leave at 8:50.
Yes. I think she testified that she leaves at 8 because she's supposed to be there by 8:45. But the surveillance video shows her arriving at 9. The affidavit supports that she arrived at 9. So my extrapolation of that is that she left between 8 and 8:15.
So we have a block of time between 7:30 and 8:15 that is unaccounted for.
Yes, and many events per the victim's testimony occurred in that 45-minute block, which I believe become less probable when you remove defendant from that situation. I would also reiterate or to bring up for the first time that my client's witnesses testified that the sister was actually the party involved in the assault, and there was testimony that my client and her sister look a lot alike.
Didn't the trial court specifically find that they were not credible witnesses?
Yes, but the credibility calculus shifts when you have actual evidence of supporting the alibi testimony. So who was at the scene, the biggest sticking point for the trial court with respect to witness credibility, other than I don't believe the alibi, was who was at the scene. Well, if we take my client out of the scene because she was at work, then maybe it brings their testimony into a more credible light. That is why this evidence is so important. That is why it needs to be in front of the court. This case should be reversed and remanded for a new trial for that consideration.
You have 1 more minute.
I'll reserve it for
Okay.
5 total for my rebuttal.
Okay.
Thank you.
Okay.
Your Honors, the court. May it please the court, opposing counsel. So, as was stated, this was a case of the assault. The motion for new trial was properly not granted for many reasons. First of which, the fact that it does not change the outcome of the trial. It does not give a strong probability of the trial. The court, when it is presented to us by the fact manager, by surveillance, she gets there by 9. The time frame is it starts around 7:30 to 8:30. It's a very short incident, even between every victim, the victim and each of the witnesses is a very short incident that occurs. And by that point, its ending could have made, by the time it ends, it starts, there's a short scuffle. And according to one witness of the defendant, the mother, she pulls them apart. According to witness fiance, there was no fight at all to begin with, and he pulls them apart. According to victim, she was attacked and they get pulled apart. Then the defendant leaves. That would leave plenty of time if this fight started at 7:30, to which she could leave, be at work, and be there by 9.
Can you discuss a little about the record where the victim testified that that the defendant was there when the police were there? Like, how does that work with the amount of time that this took?
I believe my understanding is that when the police were called, they did not come immediately. They didn't come until several hours later. And at that point, the defendant had already returned, is my understanding.
Okay.
So, and by that point, the defendant had returned. They had gone to their home. They did not answer the door and did not speak with officers and stuff. Now, returning to this, of course, the other thing is that it is incorrect to say that the trial court's ruling hinged entirely on the fact that there was no alibi witness. The court made a big point of saying that the other witnesses' credibility was in question. Their stories didn't match. That was it. They simply, one person says that there is no fight to begin with. Nothing happened. He had to pull somebody inside. The other one said that there was a fight and she was the only one involved who pulled the sister inside. The victim is the only one who says, yeah, they were both of these two were involved and they were pulled aside. They were pulled away.
And the victim was injured.
The victim was injured, Your Honor. Photographs were presented to the trial court showing that a fight did occur, that there was damage when we broke the pottery, they were put into evidence. And these said something occurred, so clearly, at least the fiance's testimony is completely false. The mother's testimony may or may not be true, depending on if she pulled them apart or if the fiance pulled them apart and they just did not share their stories with each other. But either way, their credibility is very much in question, regardless of whether this evidence gets in or not. Now, that being said, even if this evidence gets in, it's still at 9 a.m., well past when this would have occurred, well past when it could have provided anything of relevance to this case. So it would not have led to a more probable end, so it could not even meet that first burden. Secondly, to the diligence argument, there were numerous ways they could have done this. They could have just issued a subpoena duplicatum and required the bank to show up with the video. They could have had their investigators, numerous things. This is not new evidence.
So does that then go to the defendant's argument of ineffective assistance?
While I know that it's not preferable, I don't believe it actually affects it all that much. Moving on to that statement there. First off, the general rule is that the court has general high deference to the appeals courts. There's a presumption that the offenses actually are reasonable, and that it's not, and that they were acting in a manner reasonable and thought best. Defense counsel at the time had two witnesses who, in his mind, were going to provide testimony that would have supplied what he needed, as well as his own.
No, but he didn't have the video.
He did not have the video.
Something that was pretty important to him because he issued a subpoena.
It was something that could have been important to him, and yes, he could have done something else. However, based on what he had, he could have still gone forward. And if he had enough witnesses, more than once, that would have been enough to win him the trial. Nobody can control what your witnesses say when they get up there. Nobody can control what they might forget, what you think is going to come out of their mouths might change. Had they gone away probably the way he had strategized, they would have said what they needed to say, their stories would have lined up, and their credibility would not have been in question. That would have supplied everything he needed. I mean, this would also go to the fact that the defense counsel also raised manifest weight argument that clearly the court had all the information it needed with itself to find the defendant not guilty. So clearly, defense counsel and defense appeal believes that there was enough evidence put on stand to find him not guilty by raising a manifest weight argument. So it's kind of hard to both argue that there was ineffective assistance of counsel, yet the counsel provided enough evidence to prove that the
Couldn't that be an alternate argument? I mean,
it could be, Your Honor, but
if we were to say, if you argue this never counts, but that doesn't seem very equitable.
Well, it doesn't seem very equitable, Your Honor. At the same time, the point of the ineffective assistance of counsel argument, the first prong, is that they were unreasonable, that his actions did not provide enough to give the court, that they were prejudiced by it. If they had enough evidence to find the person not guilty, his actions likely had enough input. And to go back to the second point of ineffective assistance of counsel, Your Honor, is just that if they were prejudiced, and that leads us back to the same thing before. This is still a video at 9 a.m., hours after this occurred, hours after the timeline would have placed him there, doesn't change anything of the incident.
Well, there was no dispute that her commute was 45 minutes, right?
Your Honor, there wasn't any dispute at the time. However, again, this was a very quick incident.
Right. So that's where I'm saying that to get there by 9, she would have had to leave at 8:15. So we have a 7:30 to 8:15 window.
Yes.
Okay.
And that's more than enough time to have this incident go forward, Your Honor. It just in what was heard, it was not a long drawn out incident. Nothing that was in the testimony said this was a long drawn out fight. It was a very quick incident that occurred. Couldn't take more than a few minutes.
Did the victim testify that the defendant, after the assault, went back in the house and didn't come back out?
No, the victim testified that the defendant left the scene, I believe, if I remember correctly. They then returned later on, is my understanding, because the police did not arrive until several hours later.
Okay.
So, Your Honor, just based on that, we would argue that there's been no ineffective assistance of counsel. It does not meet the burden, and that the court should uphold the ruling of the lower courts.
Thank you. Ms. Nelson, you have 5 minutes.
Thank you, Your Honor. I just wanted to clarify the testimony on this hour of time. I disagree with the representation that the police didn't come immediately because that's not how it was testified to. The police were called to the scene. There was no indication of what time they showed up. My interpretation of the testimony was that they came within that hour because that's when the events in this case took place. She didn't extrapolate on the police came later. Yes, there was an allegation that my client left the scene and came back, but again, she could have left for work, which supports my client's alibi that she wasn't at the scene when the altercation occurred. Again, all of these events took place within an hour, according to the prosecuting witness, the victim, and within that hour there was still an opportunity for the prosecuting witness to do yoga, to have some preliminary words with the neighbors. The neighbors were walking, my client's family were walking her dogs. A lot happened in the time period that my client was preparing to leave for work. So I still think that even if the record is construed where the police didn't come within that hour, they came later, there's no testimony to kind of clarify any of those after events. And the record still shows through the motion for new trial that my client was at work at 9 o'clock. And the question really is whether or not the victim's testimony becomes less credible because of the fact that the alibi defense would have been solidified with third-party, independent, neutral evidence. That's really the crux of this case. The prosecuting witness's testimony can remain completely unchanged. But with the introduction of that new evidence, does the credibility calculus shift? And I think the answer to that is yes, and why there's still a strong probability that the outcome would be different. So even if we have different characterizations of the testimony and what actually occurred, I think a lot happened within that hour, but I take counsel's point that it could be construed that the police showed up later. I admit that maybe I put a little more advocacy into my representation, but that's really what we're dealing with is credibility, right? And there are no further questions on the events in this case and the testimony and how it played out. I maintain that this case should probably reverse on ineffective assistance of counsel unless this court finds that my defense counsel acted with due diligence and the motion for new trial should have been granted. If there's no further questions, we ask this court to reverse.
Thank you. Thank you, counsel. This case has now been submitted and we will issue a timely decision.